There are several common causes of actions in legal proceedings. Negligence is probably one of the most common, and I'll look at this in a little more depth a little bit further into this unit. Also, breach of contract is one that you'll see fairly often, so that's another one I want to cover in more depth. All of these are covered in the book in a fair amount of detail, and you really should read through all of these because they're very important to understand, and again, may show up on a test or quiz later. Negligence. To prove negligence, there has to be a duty owed the plaintiff. That duty was breached, and it caused an injury to the plaintiff. We'll look at this in a little bit more depth. Negligent misrepresentation, you have a defendant who failed to exercise reasonable care and supplied false information, causing a plaintiff to suffer a pecuniary loss. Reasonable care, reasonable duty, you'll see these terms in a lot of the different laws that relate to an interaction between two parties. And so it's kind of interesting to understand and try to understand what reasonable means in these cases. Breach of contract. The defendant breached a bargained for contract with the plaintiff. And a breach of implied warranty. The defendant's product or services failed to satisfy basic expectations of fitness. Invasion of privacy and publication of private facts. The publication of private facts that were offensive and not of public concern. Unjust enrichment. The defendant knowingly obtained a benefit from a plaintiff in a manner that was unfair, and it was inequitable for the defendant to retain the benefit without paying for it. Okay, so for instance, I may have tried to buy something from you, but I lied about its provenance, and so I ended up buying it from you for a very small amount of money. Or worse, I tried to sell you, say, something that had an invalid provenance, and I took the money from it. So there's a number of different ways that you can look at unjust enrichment. In state consumer protection laws, the defendant's conduct constituted unfair competition through unconscionable acts that were unfair or deceptive acts of trade or commerce. So let's look at negligence in a little more depth. And like I said, this is one of the more common causes of data breach related lawsuits. And it's a common law tort. There are precise rules that are developed through court rulings, and unfortunately they vary from state to state, as I said before. But there have to be 4 elements that are proven for there to be negligence. The defendant owed a legal duty to the plaintiff. The defendant breached that duty. The defendant's breach caused cognizable injury to the plaintiff. Cognizable is just that it's something that you can see, feel, touch, weigh, whatever. But it's an injury that can be observed. First, the first 2 elements typically are not subject to much dispute in data breach litigation. You owed a duty to the plaintiff, the defendant breached that duty. Well, in a data breach scenario, it's pretty simple. You had card data, you were hacked, card data was stolen. You had that legal duty to protect that card data. It was breached, the card data was stolen. You breached that duty to protect it. The legal duty is supported not only by state law, but also common sense. For instance, if you're collecting credit card data, it imposes a legal duty to protect that data. But compliance with the DSS is mandated by the card networks. So in other words, if you have card data, you have to be compliant at all times with the PCI DSS. And this is hard to do. Companies change networks, companies move data around. They do a number of different things that may expose that data. But common sense suggests that a company would do whatever it takes to protect that data. So that means if you have to start thinking about security when you're designing new networks, writing new applications or whatever, so that you understand what might happen to that data which you have a duty to protect. The defendants claim they are hacked by a third party. Therefore, they didn't breach a duty of care. They were hacked. This is generally rejected by the courts. Courts reason that a company played a key role in allowing the hack to occur because they didn't protect the data. They had the data for some reason in a way that it could be reached and hacked by a hacker. Therefore, you were a participant in allowing that hack to occur. The courts use the following factors in determining if a duty exists. The foreseeability of harm to the plaintiff. If you're holding card data, you should probably see that if that card data is stolen, there could be harm to a plaintiff. The connection between the defendant's conduct and the injury suffered. Moral blame attached to a defendant's conduct. In other words, if I just really didn't care about the data, I didn't patch my systems, there's probably some moral blame there. The policy for preventing future harm. A burden to the defendant and community to impose a duty to exercise care with a resulting liability for a breach. Cognizable injury, as I said, is the largest barrier to the plaintiffs. Demonstrating a breach of legal duty caused that cognizable injury can be difficult to do. State courts have worked out how to determine if an injury has occurred, and the plaintiff, quite frankly, may be successful in some cases and not so in others. Again, it may vary by state. They apply often what's called an economic loss doctrine, the principle that a plaintiff generally cannot recover for financial harm that results from injury to the property of another. So there's two primary differences among the various versions of electronic loss doctrine. Some states recognize that there's an independent duty exception to the doctrine, and other states recognize an exception to the doctrine that where there's a special relationship between the plaintiff and the defendant. It's not so much that you understand those two differences as much as it is just to understand that a cognizable injury has to occur, and there are some exceptions that may be applied at the state level based upon how they look at the economic loss doctrine. The plaintiffs suing for data breaches or inadequate data security face their best chances in negligence claims because you can demonstrate actual harm resulting from poor data security. Causation is another thing that has to be proven in negligence. The plaintiff still has to demonstrate that the breach of duty caused the injury. The defendant must link the inadequate data security to the identity theft or other harm. This is sometimes very difficult to prove. The courts are willing, however, to make reasonable assumptions. For instance, all our Social Security numbers are stolen from company A, and immediately thereafter, identity theft starts hitting our credit cards, bank accounts, all kinds of stuff. That's probably a clear indication of the two things being connected. However, we can't really show that that the hacking of company A actually resulted in that identity theft that occurred immediately afterwards. Causation is easier to prove if duration from the breach to the identity theft is short. So again, if it happens right after the breach takes place, you're probably going to be successful in getting a little leeway on what that reasonable assumption is. If it happens 6 months later or a year later or doesn't happen until the next year, it's going to be most difficult to prove that link between the breach and the harm. Breach of contract is another common claim by plaintiffs. Precise elements of breach of contract varies by state, of course, and the laws are set by common law. However, most of the contract laws at the state level are through adoption of what's called the Uniform Commercial Code, so they're fairly similar. A contract, the plaintiff has to show that there actually existed a contract between the plaintiff and the defendant, and the defendant's breach of a duty was imposed by that contract, and damage was caused to the plaintiff as a result of the breach. So a contract often has data security provisions where I might say to the company A, you must protect my credit card data by being compliant with the PCI DSS, the latest version of the PCI DSS, at all times. And then if a breach occurs, then I have a contract provision which may allow me then to pursue a lawsuit under breach of contract. By the way, I might also be able to pursue it under negligence as well, and so it may be much easier for me to prove harm. Breach of contract, there are three primary methods that a plaintiff could attempt to bring a breach of contract arising from a data breach or poor data security. You could sue for the breach of an express contract to provide a specified level of data security, and it's the most likely route for success. This is what I was talking about earlier with that provision in my contract for data security. You could claim that you had an intended or that you were an intended third-party beneficiary of a contract between the defendant and another party, in which the defendant agreed to provide a certain level of data security. This is a little more tough to prove that you were actually an intended third-party beneficiary of a contract. This might be a case, for instance, where a company that has your credit card data actually has it stored someplace else on another system someplace with a third party, and that party is hacked or the company is hacked and your data is stolen. The plaintiff could claim that even though there was not an express contract with the defendant, you're still covered. So the parties had an implied contract. The defendant agreed to provide reasonable level of security, and therefore you can argue that you were harmed under the breach of an implied contract.